Good morning, everyone. The Senate Judiciary Committee will be called to order. Are there any bill introductions? Any bill introductions from any committee members or anyone in the committee meeting room? Anyone on WebEx online? Seeing none, then we will turn to the next item of business on our agenda. We will open the hearing on House Bill 2075, allowing venue for an adoption when the state is the agency to be where the state agency or its subcontracting agency has an office. And we will ask Mr. Thompson, our revisor, for a bill brief. Thank you. Mr. Thompson.
Thank you, Madam Chair, and good morning, committee. As the chairperson said, House Bill 2075 deals with venue for agency adoptions. Generally speaking, venue, of course, means the place where legal action may be filed and heard, and the bill is amending KSA 59-2126, which is the venue statute for adoptions, and it would provide that in an agency adoption situation, when the state or a state department is the agency, that venue can be the county where the department or any subcontracting agency has an office. All of the other venue options in current law are unchanged. So those are available as well. And I will stand for questions.
Thank you, Mr. Thompson. Committee, any questions for the revisor? Seeing then, none. Thank you, Mr. Thompson.
Madam Chair, I did forget one thing. This is a carryover bill. So if you do decide to work this and move it forward, we do need to update the dates. So I would offer that technical amendment at the appropriate time, but just wanted that in the background so we didn't forget.
Thank you. If we work on this, then we will need those technical amendments. Indeed, I'm looking up to see the vote on the bill as it came to us out of the House.
Representative Humphrey.
I'm sure. And I see it. Well, we will, just a moment, please. So for those following all online, the vote count doesn't seem to be on the legislative website, which is why I'm having trouble pulling it up. But I think the Conferee proponent Representative Susan Humphreys can probably answer that for us. So with that, then we will turn to proponent in-person testimony and invite Representative Susan Humphreys to the podium and to committee. Welcome.
Thank you. It's great to be here. Hi, committee. Thanks for hearing this. The House Judiciary has actually heard this bill twice and passed it out of Judiciary Committee twice, and that would have been in 2020, and then of course we were cut short. In 2020, it passed the House 124-1. And I don't know last year I've forgotten what happened last year, but I'm not even sure. Well, anyway, but the reason I'm a proponent of this bill is because several years ago, we reworked the adoption statutes. I was on that Judicial Council committee, and we worked for a year and a half, almost 2 years, to update the adoption statutes. And one of the things we changed was the venue where an adoption could be filed. And we made it a little tighter because we didn't want people judge shopping, so that they couldn't file it in any county, but instead it had to be the county where the agency had their principal place of business. So if it was a private agency, it had to be where that agency was located. And what we found out, adoption attorneys, and actually today I'm really here coming to you as an adoption attorney more than as a House, as a representative for the House. So what happened was when we started doing adoptions after we had passed that rework, we found out that there were times when it was a DCF adoption, so it's a foster to adopt, that we had trouble knowing where to file the adoption. Because, for instance, I live in Sedgwick County, I want to file a DCF adoption in Sedgwick County, but maybe the couple lives in Harvey County and the child was a foster child in a different county, but I want to file it in Sedgwick County, I can't because the principal place of business of DCF is not in Sedgwick County, it's here in Topeka. And so what we wanted to do is just change the statute that when it is a state adoption, when it's a state agency adoption, it can be filed wherever there's an office. Of course, DCF has an office in Wichita. They have them all over the state. We want to be able to file the adoption where there is anywhere where there's an office. And the other thing that we ran into is in Western Kansas, for instance, someone might be doing a foster to adopt filing, but there's not an attorney there who can do it. And so they might ask an attorney in Sedgwick County. Well, this would mean I would have to go out to that county to do it where the couple lived, instead of just being able to file it in Sedgwick County, which now everyone can agree to that, and I have done that before, but it would be easier if we could file it wherever DCF has an adoption or an agency location. And I think it would also help in those western counties where there's not as many attorneys doing adoptions, and we would be able to get those done sooner. So it's really a little thing. I know we always say that, but I really think this is true in this case. I would appreciate you all passing it out. I think it's something that we can just get behind, and we can change it immediately and make it easier to get these kiddos adopted. So thank you, and I'm happy to stand for any questions.
Thank you, Representative. Are there any questions, since this is our sole proponent in-person conferee, seeing none other in the committee meeting room? Do we have any questions for the representative? Yes, Senator Baumgardner and then Senator Gossage.
Thank you, Madam Chair, and thank you so much, Representative Humphreys. I don't have a question, but I have a thank you, because what we do know is there are families that want to adopt children, particularly those from foster to adoption. And anything we can do to speed up that process from 4 to 7 years for these children so that they have that forever home. So thank you.
Thank you.
I'm absolutely in support of this. Thank you so much.
Thank you, Senator Gossage.
Thank you, Madam Chair. Thank you so much, Representative, for being here. You just have enlightened me. I had no idea that, if it was in Sedgwick County, let's say, that it would have to be filed in Topeka. Is that what I'm hearing you say?
Well, the way the statute stands now, it's the county where the family lives or where the child lived previously or where the principal place of business is. So, for instance, I did a foster adopt a couple who actually lives in Johnson County. The child was in Wyandotte County, but all of their family lived in Sedgwick County. They wanted to file the adoption in Sedgwick County, and we couldn't necessarily do it because it either would have to be in Johnson County, in Wyandotte County, or in Shawnee County. So we couldn't do it unless we got everyone's permission, which we ended up doing, but it kept them from being able to file the adoption. That's just one instance.
So just to clarify, when you said the family was in Sedgwick County, which...
I'm sorry, I probably just spouted that out. The adoptive couple lived in Johnson County. They were foster parents. Their foster child had lived in Wyandotte County. But they grew up in Sedgwick County, and they wanted to, have an adoption celebration. They wanted to do it in Sedgwick County so all of their extended family could be with them for the adoption. And that's how we ended up doing it, but we had to go through a whole circle of things rather than just being able to file it in Sedgwick County. That's an issue of preference, but when we're talking Western Kansas, it is actually an issue of finding an attorney who's willing to go out there and do that.
And this bill would do what to make that better?
What this changes is it says that we can file an adoption in any county where the state agency has an office. It's not their principal place of business. It's just they have an office in that county. So DCF does have an office in Sedgwick County, but it's not considered their principal place of business.
And who decides?
Where it's filed. It's a decision between DCF, usually the adoption attorney, and the family where they would like to file the adoption. If we do this, their venue would be several different places, would all be appropriate. We just need to file it in an appropriate venue.
So they would have more options?
Yes.
Okay.
Yep.
Thank you so much for the clarification.
Yep.
Thank you, Madam Chair.
Thank you. Committee, other questions for Representative Humphreys? I want to echo the thank you and the gratitude the Senator Baumgardner stated, and I think it's particularly appropriate today on the day where we have the March for Life here in Topeka from the Performing Arts Center here to the Capitol, that we're working hard as a legislature to make adoptions easier and the process not be the obstacle to get these kids forever home. So thank you for championing this bill. I recall when I was in the House, in House Judiciary in 2020 that we voted on it, and I was part of the 124 who voted yes in the House. So thank you for continuing your efforts to bring this as a legislature. You bet. Thank you. Committee, are there any other conferees in the committee meeting room who are neutral or opponents of House Bill 2075? We don't have any on the agenda, but just wanted to make sure we weren't missing anyone. Any neutral or opponent conferees online? Seeing and hearing none, then we will close the hearing on House Bill 2075 and open the hearing on House Bill 2362, which modifies the elements of and making changes to the criminal penalties of abuse of a child. Again, our focus today, where we are having the March for Life on the Capitol, to the Capitol today, is children and what we can do to help and protect children. So with that, Mr. Reviser, if you'll give us the bill brief.
Thank you again, Madam Chair. House Bill 2362, as you noted, modifies the elements and makes other changes to the criminal penalties for the crime of abuse of a child. The amendments here are in KSA 21-5602, that is the crime of abuse of a child in current law. There are 3 ways that you can commit this crime, and they're noted there in the strike type. But the new changes would change the crime so that committing any of the following acts against a child under 18 years of age would be punished. And I listed these 7 different offenses there in the bill brief, just kind of in order of how they appear. Everything from knowingly torturing, cruelly beating, cruelly striking, or cruelly kicking, to cruel and inhuman corporal punishment, to physical restraint that can include caging or confining in a space that's not designed for human habitation, or binding someone in a way that's not medically necessary, recklessly causing great bodily harm, abusive head trauma, permanent disability or disfigurement, and then knowingly causing great bodily harm, and the other things I just mentioned, or knowingly inflicting cruel and inhuman corporal punishment with a deadly weapon, or knowingly impeding the normal breathing or circulation of the blood by putting pressure on the throat, neck, or chest. You may recall that one was added just a few years ago to another crime, and that's been picked up here as well. Essentially, all of these offenses are listed there in subsection A, and then in subsection B, the penalties are provided. The first 3 offenses are severity level 5 if the child is at least 6 years of age, and it goes up to a severity level 3 if the child is under 6 years of age. And then the penalty for the acts described in number 4 there, the recklessly causing great bodily harm, etc., that's a severity level 4 person felony. And then the penalty for the last 3, 5, 6, and 7, the knowingly doing the very bad things that I described earlier, that would be a severity level 3 person felony. So that's essentially what's in there. I'll give you the same reminder as on the last bill. This is a carryover. There are 3 2020 dates that would need to be updated. And I also know at the chairperson's direction that the proponents have some amendments they're considering and working on that they might want you to consider. So I'll be happy to discuss those at the appropriate time, and I'll stand for questions now.
Committee, before we entertain questions, wanted to talk to our technology folks in the committee meeting room. I'm checking on the video as people in the community can watch, and I don't see video is up. Is that just on my screen, or do we have video going as well?
Thank you, Madam Chair. I am currently communicating with the AV team on this. It seems that there is a problem connecting the Cisco cameras to the WebEx client. So although you can see what's being displayed on the TVs here, on YouTube, there is no image being projected to YouTube. However, if If the audience wants to see what's going on in the video, they can go onto the Harmony client. For some reason, it is displaying on there, but not on YouTube. But we are currently trying to fix this problem right now, Madam Chair.
Great, thank you. Appreciate that hard work and that there's another option for those who want to follow online. Thank you. Committee, any questions for the reviser? Yes, Senator Thompson.
Thank you, Madam Chair. Thanks, Jason. Quick question on line 17 about knowingly inflicting cruel and inhuman corporal punishment. My only concern about that is there are some parents who, might decide their child needs a little spank. They're misbehaving in a store. I know there will be people who see someone spanking a child and will say that's cruel corporal punishment. How do we prevent a parent's normal correction of a child from being categorized in that way?
Mr. Thompson, if you can answer that, thank you.
Thank you, Madam Chair. I'll give the basic response of it's qualified with cruel and inhuman, so we've got to rise to that standard to be an offense that can be prosecuted. So hopefully the prosecutors who are coming up will give you an idea of how they would enforce that. As you know, with any crime, we have the option of being as narrow as possible, so that we only cover the criminal conduct that the legislature wants to cover. But we also have the option of being too narrow, so that maybe we permit conduct that you don't otherwise want to permit. So we're trying to walk that balance, and the language, at least presented here by the DA's Association, is the cruel and inhuman corporal punishment. They felt like that was an appropriate qualifier. So I'll stop there and hopefully let them speak to it a little more specifically.
Senator Thompson, any follow-up?
Yeah, I'm reading the definition of corporal punishment. It's a discipline method in which a supervising adult deliberately inflicts pain upon a child in response to the child's unacceptable behavior. I'm guessing I would want a little more clarity on that particular line to protect parents, because I guarantee you I've known about situations where somebody swatted their kid in the store, said, hey, behave, and somebody reported them. And that's a big concern to me, because it creates all of these other things that then have to take place with a parent defending themselves from, or for being able to just, Johnny, be nice. That doesn't work sometimes. I've raised 3 kids. That is my only concern with this bill, I think, is that particular line and defining it a little more clearly.
Thank you. Yes, Senator Haley.
Could I, Madam Chair,
I'm sorry, yes, Mr. Thompson.
Sorry, I just want to interject 2 very quick notes so that we don't lose track of that question. And thank you, Madam Chair. First, I'll just note that this is the current law. This is one of them that we're just replicating. It's there in lines 13 and 14, inflicting cruel and inhuman corporal punishment upon any child. So that's the current crime. Hopefully that helps the prosecutors explain sort of how it's being enforced, maybe how it's been interpreted by the courts. I don't have that background right now, but I'll point that out first. And the second thing I would say is don't confuse, I don't want the committee to confuse the reporting and sort of civil matter of the child need of care issue with the criminal matter, right? So if I see someone doing something to a child and I report that, that's a civil issue. I'm reporting them to an agency or law enforcement, and they're investigating that to see whether that's a child in need of care. And then there might be criminal charges, but this is only the criminal side. So just kind of keep that in mind. It's 2 different things. So if you are concerned about reporting corporal punishment in that context, that's a different bill, a different issue. If you're concerned about it being prosecuted, that's this bill.
Okay.
Does that help?
That does. Thank you, Madam Chair.
Thank you. Senator Haley.
Just to drill down, Madam Chair, thank you briefly on the question. Do we, Mr. Thompson, in statute have a definition already of what is cruel or what is inhuman? Of course, we know what corporal punishment is, but to that degree, I think it's the degree. And is there, to your knowledge, any other statutory interpretation of what constitutes cruelty or inhumaneness?
Mr. Thompson.
Madam Chair, Senator, to my knowledge, there is not a definition in the criminal code. That's not to say there hasn't been one developed in the case law. So I'm going to lean on the two prosecutors you have coming up to maybe give you a little bit better indication of that. But I'm not aware of a statutory criminal code definition.
Okay, and I'm sorry, Madam Chair, Mr. Thompson, on this. Where are we procedurally with this? I don't have my laptop. What did this do in the House, or where are we with this measure?
This is a hearing on the bill. It passed out of the House. Let me pull that up. Do you have that information, Mr. Thompson or Natalie Nelson? I think our researcher is going to answer that for us. Ms. Nelson?
Yes. Yes, it passed out of the House 124-0. So it had a hearing in House Committee of Judiciary, and that passed it out of that committee.
Thank you, Ms. Nelson. Madam Chair, Mr. Thompson.
Senator Pyle, did you have a question for the reviser?
Yes, I did. Your first answer to Senator Thompson kind of left it like there's a vagueness with cruel and inhuman, and that the prosecutors or the judge have quite a bit of leeway there to determine what constitutes that. Would that be a correct assessment?
Madam Chair, Senator, there may be significant clarification in the case law that I just don't have at my fingertips. I won't go as far as to say cruel and inhuman are terms of art, right, as we would use that legal term, right? I don't have a definition at my fingertips that's in the criminal code. And I would say that the prosecutors that you're about to hear from would probably tell you not to try to do that. Just for the reason I stated earlier, right? You're trying to walk the balance of describing the conduct in a specific enough way that it can be not vague and withstand constitutional muster, right? Because your crimes have to be specific. They can't be vague. But you also don't want to be so specific that conduct that you think would be cruel and inhuman when you encounter it somehow doesn't meet that definition, and then we're back here trying to amend the definition to cover something you thought already should have been covered. So they're trying to walk that line. I would say there's probably significant clarification on this in the case law, and I hope they can clarify that. I would also say that ultimately any criminal finding is by a jury. So you present this question to them. You say, was this conduct cruel and inhuman? The prosecutor thought so. They brought the case. Did they prove the case beyond a reasonable doubt? And the jury then gets to decide ultimately.
All right. Thank you. I'll save my other questions for the test.
Senator Gossage.
Thank you, Madam Chair. So two things. One, you said this is already in statute, which it is. We're just adding the word knowingly. And I would be curious to know, as I think Senator Thompson asked, about how is it being applied currently? As you said, case law, what do we see? But I also know from firsthand that it doesn't just immediately go to court. As you said, it would be referred to an agency, law enforcement. Anecdotally, this was years ago, walking out of a Walmart, observed a mother basically dragging her toddler out of the store, throwing her toddler into his chair, repeatedly turning around and slapping him across the face, over and over, to where both sides of his face were beet red. I reported her. I stood in front of her car until law enforcement came. I saw that as cruel, inhuman punishment. It was referred, I got called back, it was referred to a local agency. They went to the home, interviewed neighbors, interviewed across the street. She was PTA president in her school area, and it was determined she was emotional that day, she usually doesn't do this, and that was kind of dropped. So it wasn't like immediately I reported it and this woman went to court. So it is investigated, et cetera, and so I guess I don't see this as I'm as concerned about a parent that might give a swat in Walmart. That's a completely different situation. So I do feel in what I'm seeing here that the person would still, that individual who had done this would still have some protection against what you and I would consider a normal correction of a child in public. Thank you.
Thank you. Committee, other questions for the reviser? Seeing none, then thank you, Mr. Thompson. And we will ask our first proponent, Todd Thompson, Leavenworth County Attorney and Kansas County District Attorneys Association Chair, for his testimony. He's testifying by WebEx. So please introduce yourself and welcome to committee.
Good morning. I appreciate you giving me the opportunity to speak and do this by WebEx. I'm hoping everyone can hear me okay.
We can, yes, thank you. We
Okay.
can't yet see you, so
Sure.
make sure your video is turned on, please.
It is, and it might be to your benefit not to see me. No. This is a bill that we've brought up a couple of times, and again, we're bringing it up again because of the importance. Initially, as county attorney in Leavenworth, we had a young child, approximately under a year old, that had about 27 broken bones. That child did not fit within the statute that we have for abuse of a child. The punishment was not commensurate with the crime for that as well, of a level 5 person felony. In our belief, we needed to have something that affects more. And we had 2 young children recently that were handcuffed, and the statute more or less applies for abuse of a child. And I would tell you, according to the law, whatever the facts most applicable to the statute, that's the statute that we are supposed to charge. And generally, abuse of a child would make that measure. This bill would give our state much better opportunity to protect our children, a much better opportunity to assure that people that have no conscience when they abuse these children in such a way to actually serve the punishment, because these children are ones that we should be doing everything we can protect, and they can't protect themselves from these abusers, and we need to be the ones that are trying to do our best to make sure the consequences are commensurate with the crime. And the statute as is written now just is not doing that job. To discuss the point, I know there was a lot of talks or discussions about the definition of corporal punishment and cruel. And I will note, just as Mr. Thompson has said, Jason, there's a lot of Thompsons on here today, that this is part of already existing statute. The legislature has used this before. It's been State v. Della Torre, which is a 300 Kansas 591 2014 case, gave a little bit of guidance of what cruel and inhuman corporal punishment would be defined as. And basically, as you could imagine, it's not just corporal punishment. You have to prove whether it's cruel or inhumane, or inhuman, as it's said in the statute. These we're not really changing anything that isn't already in law. What we're asking for is a more severe penalty. But I do understand everybody's concern about what that rises to. And as the example is correct that was used previously, not only does a report have to be made, but law enforcement has to then write that report. Prosecutors' offices then have to review to feel if it is corporal or inhumane. The court has what's considered a preliminary hearing where evidence can be presented, which the judge can decide whether that they consider that to be inhumane or cruel corporal punishment. And then finally, the person who's being charged with this crime has the opportunity for 12 people that are their peers to make a decision on whether that's corporal punishment, whether that's inhumane or cruel corporal punishment. And it's a specific intent crime, which means they have to show that the person doing that had the mens rea or the specific intent to do something in that nature for that crime. I understand that, you might see that as vague, but I feel like it is very clear, and it's a very high burden, more so than a light spanking or a swaddle or yelling at or something like that you might see a parent do this is cruel and this is inhumane. And there's a lot of people that will review that before. And again, it exists today. That being said, this bill is just very important. It's just we're not prosecuting the kids and the aggressors against the kids the way they should be. We're not doing enough to hold people accountable. And I really hope that we can get this bill passed. And I stand for any questions. And I thank you for the opportunity to speak, particularly by doing it for WebEx. And I'm sorry you can't see me today.
Thank you, Mr. Thompson. Committee, because we have two conferees by WebEx, it's probably logistically easier to take questions immediately after the testimony. So with that, we will open it up for committee questions for Mr. Thompson. And Senator Pyle has a question. Senator?
Thank you. You're adding the word knowingly. Describe to the committee what knowingly does to a parent who's administering corporal punishment in a public place.
Mr. Thompson?
Knowingly is to have the knowledge of, to be aware. So I think besides the self-explanatory definition of that, I would hope that would make sense. If that doesn't, I will get you the legal definition in just 1 second.
Actually, we're going to move on in the interest of time. And Senator Pyle, did you have follow-up?
Yes, I do. The question that I would ask to follow up on that is, is there ever a time that a parent administers corporal punishment that it is not knowingly?
Mr. Thompson?
Honestly, there could be sometimes there is a reckless part of that statute. There are reckless that has been added. So it could be something that, for argument's sake, that they didn't do intentionally or knowingly, that they inadvertently did. Without just trying to figure out or make up scenarios, there could be examples that someone could try to argue. Generally, when someone is doing some form of punishment, I believe that they probably know what they're doing.
Okay, thank you.
Thank you, Senator. Senator Haley, Senator Thompson, and then Senator Baumgartner. So, Senator Haley?
Thank you, Madam Chair. I was right along the line with Senator Pyle, and the question has almost been answered. I mean, if it's methodically, if the striking of a child is methodically, then the mens rea, at least Mr. Thompson, I gather, would meet this test. But again, if it's just in a response or rage, I think Senator Gossage mentioned an incident that she witnessed where the parent or the guardian was just immediately angry at the circumstances and did not form really necessarily the mens rea to injure the child. And then, if I heard correctly, it was adjudicated later that it was just a rare instance and there was no crime or any particular punishment. So I guess Senator Pyle's question has already been asked and answered, if I'm understanding correctly. But secondly, beyond physical injury to a child, Mr. Thompson, do we ever delve into, in our statute or in society, into mental or emotional cruelty and or abuse systemically or ongoing as between a guardian or parent and a child? Is there any such crime out here for in our statutes that you're aware of where a child is so emotionally or mentally scarred that we would bring in action?
Mr. Thompson?
Senator Haley, the only way I would imagine that could occur would be through a child in need of care statute, abuse or neglect of a child, which that would apply. But in regards to the mental health part of it, or the mental abuse part of that, and that could be preceded, but not really in a criminal manner unless there's some causal way to connect that. So, for my personal knowledge.
Thank you, Mr. Thompson. I just think that there can be some, this is my opinion, editorial opinion, there could probably be more lasting scars done to a child through a mental or emotional ongoing abuse, methodically inflicted, if you will, than a spanking but anyway, thank you, Madam Chair, to be reserved, and thank you, Mr. Thompson.
Thank you.
And Senator Haley, I don't disagree. Again, like a spanking would probably not affect that would be just a reasonable corporal punishment, depending how it's done. Just to go back to the knowledge part, it's something that's done. Knowledge is something that's done. Obviously, it kind of said it's knowingly. It's done without mistake, accident, or some other innocent reason. Again, those are the factors that juries usually have to determine, a judge determines, and a prosecutor determines. But, mental health, I agree, is a very important factor. It'd just be it's something that would be hard to measure, I guess. I'd be interested in what that could be. But at this point, I'm just hoping that we can get this piece of legislation passed.
Thank you. Senator Thompson?
Thank you, Madam Chair. Yeah, I don't disagree. I think this is important legislation, no doubt about it. My only concern is I understand how the societal definition of corporal punishment has changed these days, and where it can lead. And that's my biggest concern about that one line. And I don't know if there's anything we can do to define it more clearly. I think Jason Thompson's done a good job with that, but that is probably my biggest concern on this, about where we're going with it. I had a situation when my son was 3 years old. He was acting up in the back of church, and I kept telling him, I said, "You got to be quiet. We're going to take you outside." Well, he didn't settle down, so I picked him up, started to leave the pew. He grabbed the pew and yells, "Don't beat me." Okay? Everybody turned around and looked at me. And, this is the kind of thing that happens with little kids. They don't understand what they're saying, and other people misinterpret it. And these days, you could be in serious trouble. That's my concern. And that's it. It happens. It just happens. Thank you, Madam Chair.
Thank you. Senator Baumgardner, then Senator Pyle.
Thank you, Madam Chair, and thank you for the testimony so far, Mr. Thompson. My question has to do, there's been a lot of talk about parents and their children, and yet in the Senate Education Committee, we have heard about children that have acted out and as a part of restraint and seclusion have been put in basically the broom closet, have been locked into, I know in one school district, an elementary child was locked into a conference room for the day. We also heard testimony where a child was placed in a cage that was made out of basically chicken coop wire and 2x4s. So I want to make sure that if someone in a school or in a daycare or an after-school setting, if this were to occur, that the same action could be taken by parents against these individuals.
Most definitely.
Just a moment, Mr. Thompson. Is that a revisor question, or did you want to direct that to Mr. Todd Thompson?
Todd Thompson.
Okay, yes, thank you. Go ahead, Mr. Todd Thompson.
Sorry, Senator Chair, and I didn't mean to interrupt you. It's hard to do it by this way without seeing everybody. But yes, most definitely, the statute doesn't warrant a specific. It doesn't warrant that the parent be the party. It just warrants the type of abuse.
Okay, thank you. I think that's important because we do have some bad actors and some bad action that occurs. Particularly, we find the victims are children that are nonverbal and that on occasions will have emotional outbursts. So I think that's important for us to keep in mind. Thank you, Madam Chair.
Thank you. Mr. Revisor, Mr. Thompson, in those instances when it's not, if it's described as it was by Senator Baumgardner in a school setting and a parent wants to bring a cause of action for assault or other abuse, other injuries, that would be a civil cause of action that the parent could bring against the teacher or the school? I'm sorry, that's for the revisor.
My apologies.
Thank you, Madam Chair. Jason Thompson this time. You're correct. If you're talking about a parent suing a school or suing a bad actor, that's a civil matter, but only a prosecutor can bring a criminal action. So the parent would have to talk to the prosecutor to get the crime prosecuted. But to County Attorney Thompson's point, they are allowed to prosecute any bad actor. It doesn't have to be the parent. It's just any person who does any of these acts against a child under 18 years of age. They don't have to be related or anything like that.
Right. Thank you for that explanation. Senator Pyle.
Thank you, Madam Chair. And I just some thoughts on this while we're visiting this issue. There is a possibility that maybe we could do something here to strengthen parental rights, because I do agree with the senator from Johnson, and both senators from Johnson, but in the instance of considering just the facts that when Senator Thompson tells his story about his grandchild screaming out, beating, parents today, you need discipline. If you don't want more Carr brothers and more problems like that, you need discipline. Parents struggle enough. The stress, can you imagine the child screaming in the cart, screaming and hollering in the store, what that does to a young mother, with children. So they need ample opportunity to discipline, and they don't need to live in fear that someone's going to turn them into an agency and that they're going to have legal costs and other financial burdens. So I don't know how you do that. But I think there almost needs to be some kind of exceptions that target parenting so that they don't have to go through frivolous charges and face those kind of things. I don't know what the answer to that is, but I know that if somebody charged Senator Thompson with beating and had an investigation and he'd had to answer to some social worker or had them come and check that grandchild or perhaps had that grandchild removed from the home to be checked for any bruising or any other problems, I'd like to see some protections for families because I do believe there is a place for corporal punishment. And perhaps the Carr brothers, I don't know how they were raised. I don't know what their parents did. The prisons are full of people that lack discipline. But our goal is to raise disciplined citizens that can be the kind of citizens we all desire. But we don't want harm. We don't want bodily, physically harm. We don't want, and you can get into the whole aspect of mental abuse when you're talking about discipline, but there is an old adage that says, spare the rod, spoil the child. And I think that we all know that, and so there's a balance here. And I certainly don't want this bill to make knowingly more of a challenge to parents that I'm knowingly spanking my child on the buttocks and I'm doing it in Walmart, and now I'm going to be charged, or I'm going to be questioned about how I discipline my child. And I know that they already do live with that fear in a large part. And I think we ought to figure out a way to put some kind of protection for that. I don't know what that is. I don't know how you do it. But I know we don't want to add and make it worse. Thank you, Madam Chair.
Thank you. Committee, I have to leave committee right now for another previously scheduled meeting, and we'll have our very capable vice chair, who was the chairman of the committee last term, conduct the committee meeting from here on out today. Thank you.
Thank you, Madam Chair. Are there any more questions from Mr. Todd Thompson? Thank you, Mr. Thompson, for your testimony. We now have Alice Osborne, Sedgwick County Chief Attorney, Kansas County and District Attorneys Association. Are you online, Ms. Osborne?
I am. Can you hear me? Yes. Can you hear me?
Yes, I can. Please introduce yourself and proceed.
Good morning, and thank you for your time today. My name is Alice Osborne. I'm a Chief District Attorney here in Sedgwick County. I'm in charge of a unit that deals with child abuse, sexual assault, crimes, and domestic violence. My understanding is that I've been asked to talk to you about adding the word burning to House Bill number 2362. Also, a request to give a definition of the word torture. And I've been listening to a lot of the senators, and I may have some answers on concerns with corporal punishment and those concerns and what protections are for those parents, if I could address that last. So right now, how the child abuse statute reads, if you intentionally burn a child or recklessly burn a child, you cannot be charged with abuse of a child. The House bill as presented and went through the House does not include burning a child. The only option a prosecutor would have is to look at the statute for aggravated battery and battery. My proposal is to add the word burning to subsection A3A and A2. And if you intentionally burn a child, that would cover circumstances that I've seen just in the years that I've been doing child abuse, where the caregiver puts out a cigar in the toddler's chest. And that's an intentional act. Without having that defined as abuse of a child, I probably would have to charge a misdemeanor battery, because a cigarette burn or a cigar burn would only be bodily harm to a child. And that is not an appropriate remedy for intentionally putting out a cigar in the chest of a toddler. I've had a case where an infant was put in a hot dryer. That child had second-degree burns along its back that were the imprints of the dryer. In that case, we could only charge aggravated battery, and the parent didn't understand why it wasn't child abuse, because I didn't have an option to do burning. We have multiple cases where a child is burned by hot water scalding because of potty training issues. And what we'll see is a child has been submerged in hot water or poured hot water on them as punishment for potty training issues. And those children result in second, sometimes third degree burns to their genitalia. Again, it can't be defined as abuse of a child. It can only be defined as ag battery. And sometimes when these children are presented, it's a second degree burn, which causes blistering. So the issue is, well, is it only a battery because it's bodily harm? And then I'm looking at misdemeanors for this intentional conduct of burning a child. I'm also asking the amendment to allow recklessly burning a child. And these would be situations, and I recently did a case this week to a jury, were two children that were developmentally disabled by the same nurse at different times were scalded to the point where one child had second-degree burns, the other child had third-degree burns, and their skin just sloughed off of them because the nurse caring for them didn't check the water before immersing the children into the water. Again, it wasn't child abuse. I had to go forward with aggravated battery. Reckless conduct would also be considered if you were to have the water running, leave your kid in the bathtub, and then go get high. And you have recklessly put that child in danger, and that child gets second-degree burns. And also if there's illegal drug activity going on and a child gets burned by grabbing a crack pipe or something to that effect, that's reckless conduct. So my first request is to consider adding the word burning, and that would go under the House bill when it reads, recklessly causing great bodily harm, abuse of head trauma, permanent disability or disfigurement or burning, or knowingly cause great bodily harm, abuse of head trauma, permanent disability or disfigurement and burning. So that's the request that I have regarding that issue. I can go on and talk about a definition of torture if need to, or I would take any questions on the issue of burning.
Committee, you heard the response. Are there any questions? Senator Haley.
Thank you, Mr. Vice Chair, and thank you, Ms. Osborne, for being here. I appreciate your testimony here today. I guess we're looking at your written testimony. You have specifically outlined what kind of burning there would be, and you've given some details. I think I'm kind of concerned if there was something other than what's listed in the second paragraph of your testimony. So my question is, were you aware of the House hearing on this, or did you visit with them at all, or did someone that you know visited with them about including burning as one of the definitions? And if so, was this language that you're suggesting to amend into the bill offered at that time?
I cannot answer that. They reached out to me on Friday to ask to add the word burning. So I don't know if it was given to the House and rejected at that time or not. And it was Steve Kearney with, I believe, the District Attorneys Association.
Yes. All right. Thank you, Mr. Chair, and thank you, Ms. Osborne.
Committee, are there any other questions of Ms. Osborne? Seeing none, Ms. Osborne, do you have additional comments you would like to make while we're on the line?
Yes, thank you. So I also would ask the committee to consider a definition of the word torture. We have one definition in a case that describes torture as, quote, to inflict intense pain to body or mind for purposes of punishment. So I have had several cases where I believe it was torture. However, I can't prove that the person committing the torture is doing it for punishment. Usually it's a rage, or that it's intense pain to the body or mind. The cases that I have seen deal with, recently I tried a case and the little 4-year-old was beat, strangled, and had a bite mark on her cheek. Argument was that was torture. Defense counsel's like, well, the child wasn't waterboarded, in words that we could think of torture. And it wasn't for punishment. It was the dad's girlfriend was mad at the dad, so took it out on the child. So the child wasn't being punished. So it was difficult to reach that. And when there were so many different things that happened to that child, argument is that the child was being tortured. I recently prosecuted a case with the child that was found in a concrete block after being tortured by this family for months. It was the case of Evan Brewer. The only evidence the state has was a picture of the child nude in the basement with a dog collar around his neck. And then we had hours of the boyfriend of the mother of the child berating the child over and over. We didn't have video to see, but we could hear. And it was threats of throwing him in a pit of snakes, or what kind of harm he was going to do with him, punishing him and yelling at him because he didn't say good morning to him in the morning. So it was repeated conduct. And I had a few pictures of the child being required to stand in the corner. And that enough? Is that torture? But over a long period of time, to the point where the child's naked with the dog collar in the basement, I would suggest that should be torture. No pain was inflicted, but a child standing nude with a dog collar, I would submit that should be torture. Another case that I have recently, I had 2 children that were being neglected to the point where the mother and father weren't checking on them. The infant nearly starved to death. The toddler did. The toddler was tied in his pajamas to a point where he couldn't move his arms or legs, and both children were severely malnourished. Their cat, however, was fat. So the family was able to feed their pets, but just stuck their kids in their room where they starved. At least one starved. We had evidence that the child was beat. But these children were tortured. But I had to ask my pediatrician, is there pain when you're starving to death? And the answer was no, not really. But if you're starving to death, I would suggest that that constitutes torture. And then I have two cases with children that are above the age of 6. One, a child that had severe diabetes issue, but was in caregivers. He was a child needed care, ended up with an aunt. This child's treatment by these two adults in the home disintegrated over months. He started in a bed and he ended up sleeping on the lid of a plastic tote. They had to over his feet, and they put an alarm on the refrigerator so he wouldn't get food, and they had cameras in the house to make sure he wouldn't get food. This child coded at the hospital, but he's lived. But again, it was repeated long-term abuse of a child. And then the Wilson case out of Reno County, they were children that were put in a room. Their food was taken from them as punishment. And then they were required to pee and defecate in a coffee can. So I don't know if that fits my to inflict intense pain to body, mind, or mind for purposes of punishment. I did some research on a definition of torture, and it's at least 2 physical assaults or 1 extended assault or 2 or more forms of physical maltreatment or neglect resulting in prolonged suffering, permanent disfigurement, or dysfunction. It's hard to tell my community I can't charge child abuse on those circumstances if I can't meet the elements. This list would not be inclusive. We could add other things that I can't make up what these adults will do to children, but in my mind, it's torture. But it doesn't quite fit the definition our courts have given us. So this may give us a way when children end up dying that I can put the underlying felony as child abuse as opposed to endangerment or ag endangerment of a child or so forth. So that's the issue of a definition may be needed for torture. And I don't want to limit us because, again, I can't make parents or adults will do to children. But this could cover the psychological maltreatment that I heard one of the senators concerned about if you have a long-term, prolonged, abusive home that a child is put in. So that's the issue of torture.
Thank you, Ms. Osborne. I assume you will stand for questions.
Yes.
Senator Haley.
Thank you, Mr. Vice Chair. Thank you again, Ms. Osborne. I certainly concur with not limiting you with the statutory word punishment. So I was just reading the bill while you were giving this testimony, and I only see punishment except in the heading, line 17 for inhuman corporal punishment. And then again on line 25 for inhuman corporal punishment. So if I understand you correctly, taking out punishment, but retaining the intent is what you would like the committee to consider by way of amendment?
Well, it's under the subsection, Senator, where it talks about knowingly torturing, cruelly beating, cruelly striking under line 15. So if you're knowingly torturing a child, my case law tells me it means to inflict intense pain to body or mind for purpose of punishment. So when we try to define what torturing is, and I get this from defense counsel all the time that, hey, we're not waterboarding, we're not doing these type of things that you hear torturing, not, putting them in a medieval type torturing device. That the guidance, the only guidance I have is that it's for purpose of punishment. And sometimes it's just, can you punish an infant is my concern. I mean, an infant doesn't do anything to be punished for. They just lie there. But yet I have an infant being withheld food for weeks. And I have to prove that they're punishing? No, what they're doing is they're intentionally neglecting that child because they don't want to deal with it. And that's an intentional thought of that parent or adult or caregiving, but I can't prove it's to punish the child.
Well,
it's they
yeah,
would be their cat than their kid. So
yeah.
that's my
I
Sorry,
understand
Chair.
you probably may have some issues with certainly other people on this committee regarding that, because we've had some examples where it may be a cruel beating, but it may not be methodical in the mens rea. Let me just say, Ms. Osborne, I appreciate your bringing this forward. I have a real issue. I work very hard in this legislature to look at those who torture and through dominionism, cruelly torture animals. I'm known for what's called Scruffy's Law, and it's people that derive pleasure from beating or otherwise inflicting harm. Some of the worst histories of serial killers in our state, like in York County, BTK, Dennis Rader, who's still sitting on death row after torturing and cruelly, inhumanely torturing many people over decades, and he's still sitting there on death row. But that's how he started out, was just deriving pleasure from watching something defenseless be tortured. John Robinson in Johnson County, who tortured people and put them in buckets. And these people just sit on our death row and have not been disposed of because their mens rea, their mind, is to watch something writhe in pain, something human writhe in pain. And that's what I'd like to get at. Not necessarily the discipline of a child that could result in a cruel beating, but those who methodically derive some sick pleasure from doing that. So anyway, I hope that we can somehow reach a happy medium, not a happy medium, but a medium on how to define in statute what we're both trying to reach. Thank you.
Thank you. Senator Gossage.
Thank you, Mr. Chair. A very quick question. If I recall, at the beginning of your testimony, you said that if a child was burned, you didn't feel like that they would fall under any of the categories under current law or this bill. Is that correct?
That's correct.
And would it be fair to say there might be other specific type of torture, inhumane punishment, etc., other than burning that might be left out as well?
Sure. And I don't want to put burning in with torture, because I think burning is in and of itself, it's necessary to put in its own category, where torture can cover many. So if I were to charge the case and I have a child that's been covered in cigarette burns, I could use intentionally burn the child or intentionally tortured the child in the alternative, and let the jury decide, well, of course we got intentionally burning, but were they torturing? And if convicted on both, they would only get sentenced on one. But that would give me tools in my tool chest to call this what it is, which is abuse of a child.
And then do I understand that when we look at the punishments and the adjustment to the punishments to make some of them at a higher level than they are currently, are you saying that torture and burning, in your opinion, would have two different levels of punishment?
Ms. Osborne, please identify yourself again.
Sorry. Thank you, Mr. Chair.
And this is Alice Osborne. As written, torturing would be a 5 unless the child is under 6 in the House bill. And burning, if it was an intentional, would be a 3. Quite frankly, I think if you're torturing a child, it should be a 3. And I would raise it to a 3. But as the House bill is written, it would be a 5 if the child was over 6.
And final question, if I may, Mr. Chair. So then, if you were to present this amendment, it would put the burning under the category that would be the 3 offense, correct?
Yes, for intentional burning.
Thank you. Thank you, Mr. Chair.
Thank you. Are there other questions of this conferee? Seeing none, thank you, Ms. Osborne, for being online and for your testimony. Thank you very much.
Thank you.
Okay, committee. Obviously, we don't plan to work this bill today. It appears like we may have some work to do on it, and we have no other business before us. We will adjourn the meeting. Thank you.